Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. The Supreme Court recently decided its decisions in two federal vaccine mandate cases, Biden v. Missouri and National Federation of Independent Business v. Department of Labor, Occupational Safety and Health Administration. Several states and interest groups sought emergency relief on regulations issued by OSHA, as well as the Centers for Medicare and Medicaid Services. The OSHA rule mandated large employers to require vaccination or regular testing of their employees. CMS required vaccination of staff at healthcare facilities participating in Medicare or Medicaid programs. The court granted a stay of the OSHA rule pending merits review in the Sixth Circuit, but stayed an injunction of the CMS rule, allowing it to go into effect. Today, a distinguished panel reviewed the decisions and also considered the appropriate role for the various levels of government authority in setting vaccine policy. They are, in order of appearance, David Dewhurst, the Solicitor General of Montana, Dorrit Reese, Professor of Law, and James Edgar Harvey, Chair of Litigation at UC Hastings Law, and Professor Ilya Soman, Professor of Law at Antonin Scalia Law School.
Thank you to the Federalist Society for the opportunity to talk about this very timely issue. So the story really begins on this about September 9th, when President Biden held a press conference in the midst of what was a very unfortunate misadventure in withdrawing from Afghanistan, and announced that we were going to be pivoting on the issue of vaccines and responding to the COVID-19 pandemic. And what we learned is that he had several broad plans to increase vaccination among Americans. He very explicitly expressed his displeasure, and that his patience was wearing thin with those who refused to obtain the COVID-19 vaccine. And so we learned then what was coming down the pike. OSHA was going to be issuing an emergency temporary standard for a huge number of American workers at larger companies. We learned that CMS at Health and Human Services was going to be issuing a rule for healthcare workers, and that the president was going to take action with respect to federal contractors and public employees in the federal space. Several weeks later, on November 5th, we got both the OSHA and the CMS rules. OSHA came in the form of an ETS. It applied, as you all know, to employers with 100 or more employees. The vaccines were mandatory. Employers had the option of alternatively requiring weekly testing and masking for those employees who didn't want to get vaccinated, although they didn't have to offer that exception. And there were very steep fines put in place for each infraction and for willful violations of that emergency temporary standard. As we all know, everyone in America basically challenged the OSHA rule in every circuit court using the petition for review process that's provided for in the OSHA statute when it comes to emergency temporary standards. The Fifth Circuit quickly stated that the ETS stayed the ETS, finding that the petitioners were likely to succeed in showing that the OSHA mandate grossly exceeded OSHA's statutory authority. And by rule, then all of the different circuit petitions were consolidated in the Sixth Circuit. Then there was a flurry of activity where many of the petitioners, including the states in which Montana was a part, and Ohio at this point sort of took the leading role as sort of a home state within the Sixth Circuit. We all moved for initial en banc consideration. The court denied that because of an 8-8 vote. And in that denial, Chief Judge Sutton and Judge Bush both dissented, and they echoed and expanded upon the Fifth Circuit stay reasoning that the mandate was obviously in excess of OSHA's statutory authority. Shortly thereafter, a 3-judge panel in the Sixth Circuit dissolved the Fifth Circuit stay and concluded that the mandate was in fact consistent with OSHA's statutory and constitutional authority, and Judge Larson dissented from that decision. After that, many parties filed applications for a stay with the Supreme Court, and 2 of those cases were consolidated. In fact, the 2 in which the court called oral argument on January 7th and yesterday issued decisions, the NFIB case and the coalition of states. The CMS interim final rule was also published on November 5th. And this one is a simpler rule. With very few exceptions, it requires covered staff, which is most everyone at Medicare and Medicaid covered facilities, to obtain a COVID-19 vaccination. Noncompliance can result in monetary penalties, the denial of funding for new admissions at those facilities, or complete termination from the Medicaid and Medicare programs. And so it was high stakes, both for the states and for these facilities, as well as patients who rely on this funding in order to get the health care that they need. 2 coalitions of states raised challenges. And there were more coalitions, but we'll talk about the 2 that actually made it up to the Supreme Court. One led by Missouri and Nebraska, the other led by Louisiana, Montana, and Arizona. Those were filed in the Western District of Louisiana and the Eastern District of Missouri. And the states attacked the CMS rule on various grounds. They argued there is no good cause for dispensing with the notice and comment requirement that generally applies to rules that the agency has to issue. The big $1 million question that we argued that the CMS lacked the statutory authority to enact the mandate. And that even if some authority could be scratched out of the statute that would authorize something like this, this was a major question that would require a clear congressional statement authorizing this sort of mandate, and we argued that that didn't exist. And then we made a litany of other challenges to the rule, arbitrary and capricious challenges, as well as some other statutory violation arguments. The district courts in both locations enjoined the rule. In the Western District of Louisiana, there was a nationwide injunction that the Fifth Circuit later limited. The federal government sought stays from both the Fifth and Eighth Circuits, and when those were denied, they sought relief in the Supreme Court. And so, as you all know, the court heard oral argument on those arguments on January 7th as well, and we got decisions in those cases yesterday. So first, quickly, I'll talk about the OSHA decision. It's a short, straightforward decision, and it came out as many predicted. The court leaned into the clear statement, major questions doctrine. First, it determined that the ETS mandate was obviously a question of vast economic and political significance, a measure meant to ensure the vaccination of 84 million Americans, and one that has never been undertaken by OSHA before. OSHA, the court explained, may regulate to mitigate occupational risks, but the mandate confuses the important difference between occupational risks and risks that exist in general, to the general public, which means that the OSHA mandate is in fact not an occupational regulation. It is a public health regulation. And there's not clear congressional authorization for OSHA to regulate in this way. Plus, there's no other evidence out there that Congress authorized OSHA to take this sort of action. In fact, there's contrary evidence in the Senate's December 8th denunciation of the ETS. Finally, and importantly, for the CMS discussion, which we'll get into in just a second, the court observed that OSHA had never exerted this type of regulatory control before. And that was telling, the court thought. They quoted from the Free Enterprise Fund case, the lack of historical precedent coupled with the breadth of authority that the secretary now claims is a telling indication that the mandate extends beyond the agency's legitimate reach. So an important part of the analysis in OSHA, in addition to the fact that the statutory citations that the government was citing just simply couldn't carry the freight of this mandate, but the fact that this was an unprecedented action. OSHA had never done anything like this before. So that's the OSHA decision. There's a lengthy dissent by comparison, I suppose, from Justices Breyer, Sotomayor, and Kagan, and it's worth a read. And an interesting concurrence from Justice Gorsuch, where he leans in a little bit harder to the major questions doctrine. Going over to the CMS decision, and maybe provide a little bit more detail on this one since I was more intimately involved in this case, and I'm in the Federalist Society presentation stage of grief, which is somewhere in between denial and rage. But the court concluded that the CMS mandate falls within the authorities that Congress has conferred upon the Secretary. So the principal question at issue, the court concluded without much analysis that this type of mandate is well within the statutory authority that Congress has granted to the Secretary in order to regulate the Medicare and Medicaid programs. Interestingly, the decision relied upon Section 1395, 42 USC 1395, which was the statutory section that the Solicitor General relied on principally in briefing, but was not what CMS actually relied on principally when they published the IFR. They relied on different statutes that had to do with the administrative, the efficient administration of the programs. But we saw a shift in briefing to Section 1395, which has to do with Secretary's ability to regulate for health and safety of patients who are in covered facilities. And that's what the court grappled onto, and that's really what the basis of the decision is. In fact, the court held that this fits neatly, the mandate fits neatly within the language of the statutes. Now, if you have just read the OSHA mandate case, that decision, and you come to this paragraph, it will, as it did for me, present quite a surprise because, in fact, I think the situation in both cases was pretty similar, and we're dealing with similar sort of attenuated statutes, which I'll talk a little bit more about here in just a second. But nonetheless, the court concluded that this was the type of statute that contemplated a vaccine mandate. Now, in order to reach this conclusion, it sort of ignored the fact that the arguments about these authorities in Section 1395 appear in these residual catch-all provisions of definitional statutes. 1395, for instance, XE9 has to do with hospitals, and there are a slew of other statutes that have to do with defining other covered facilities. And many of those, not all of them, but many of them have these health and safety residual provisions. As Justice Thomas points out in his dissent, that's not the type of provision which can justify such a profound departure from previous practice. And as a matter of statutory construction, that's a little bit of a dubious conclusion. So the court found that this smattering of residual authority statutes found in the Social Security Act was sufficient for the omnibus vaccine mandate that applies to all covered facilities. And there wasn't a whole lot more discussion about the statutory analysis that the court undertook. But that's sort of what we have. Interestingly, I pointed out in the brief discussion about the OSHA decision that the court talked about the history of regulations that OSHA has enacted under their statutory provisions. The court did the same here, but it seemed to sort of reverse polarities. And it basically said that the vaccine mandate is similar in kind to the host of conditions that the Secretary already imposes on covered facilities. Things like training, things like credentialing, hand washing, and infection control sterilizing procedures, things like that. The court basically concluded this is one and the same. This is not a profound departure from those previous types of regulations. And so this is also something that can be neatly captured within the statutory grants of authority. In my opinion, I think the court read sort of a pixelated broadness into the statutory language. So broad that the obvious differences between a vaccine mandate and the various training, credentialing, hand washing, sterilizing procedures that the Secretary has long imposed sort of gets washed out. I think Justice Thomas points this out, and so does Justice Alito in their two dissents, that obviously this is different in kind. This is something new, as CMS recognized when they published the IFR. They've never done something like this. And there is a difference between each of those types of procedures and, of course, the sort of the irreversible nature as Justice Alito put it, of a vaccine. The court then pretty summarily dismissed the APA arguments, the arbitrary and capricious arguments, and opined, albeit briefly, on issues that the Solicitor General had failed to raise in her application. In short, they concluded the record supported the Secretary's various findings, concluded that the Secretary apparently didn't ignore the effects that this would have on rural hospitals and clinics, and the district court's other critiques of the interim final rule were apparently not deferential enough. They were too searching, and apparently the district court owed a little bit more deference to the Secretary's findings. The court also concluded that the good cause exemption was satisfied, and so the interim final rule was appropriate. They didn't need to seek notice and comment before they published. And the reasoning was that the Secretary wanted to get this out in front of the winter flu season. There's apparently no requirements that the Secretary consult with states before they publish an IFR, which strikes our coalition at least as a significant workaround from the way that the Social Security Act is designed as a quintessential act of cooperative federalism. And then lastly, the court concluded that there's no violation of the statutory prohibition on federal supervision and control over the tenure and selection of healthcare employees. Now, this was a pretty clear argument that we made, and I thought a pretty strong one. And the reasoning that the court provided, I think in one sentence, was that if we took that point sort of as it's presented in the statute, if we took it plainly, then that would call into question the host of other regulations that the Secretary has long imposed on employees and facilities under the program. Now, whether or not that's actually statutory construction or not, I guess can be left to the reader. But obviously, we think that was a serious problem, because this, in a new and unprecedented way, does interfere with the selection and tenure of employees at healthcare facilities. As I mentioned a couple times, Justice Thomas penned a very strong dissent where he talks about the lack of statutory authority for this vaccine mandate. And Justice Alito wrote a dissent where he talks about the good cause exemption and why the government did not demonstrate that that was actually satisfied. So very quickly, I'll just make a few observations and then I'll pass this along. On the OSHA mandate decision, I think this does what a lot of us expected. And I think we're going to see a continuing development of the clear statement doctrine, the major questions doctrine. And I think this potentially will have serious implications for later cases this term. Cases like the Clean Air Act case brought by West Virginia. I think that's going to be a serious consideration for the court. If the OSHA mandate did not pass muster, then I think the EPA's maybe in for some trouble on their Clean Air Act regulations. On the CMS case, I think there are some real questions that we have going forward just from a litigation perspective about what the standards of review are and what the burdens are that parties have to meet when they actually approach the court with a stay application. In the CMS case, only Justice Thomas discussed the standard, and he seemed to apply it throughout. But that's interesting and a problem, I think, in a case like CMS, because unlike the OSHA case, this was when you stack the stay standard on top of the fact that we have a lower court preliminary injunction, the likelihood that the Supreme Court will reverse is you have to look at that through the lens of abuse of discretion. And I don't think the majority opinion, the per curiam opinion, actually does that. They seem to approach this purely in a de novo posture. And that's a real problem, because allowing this rule to go into effect essentially gives the federal government full relief that it seeks. And so, by the time this is further litigated below, healthcare workers are going to have to make hard decisions about whether or not they want to submit to the vaccine or whether they're going to leave their jobs. And so, it's when the standards are not really clearly articulated or clearly applied in the stay posture. I think this leads to some questions about what exactly we're doing in a stay posture, or whether in fact this is the Supreme Court issuing some sort of final decree on this very important legal question. And if that's the case, I'm not sure that we really presented enough briefing, and there's been enough lower court development of the law and the facts on these issues to justify that. Next, what about forfeiture and waiver? The Solicitor General in this stay application left 3 bases upon which the district court granted the injunction below, left those completely out of the brief. And that alone would seem to show that the government can't meet its burden. And so, the court went out and reached these arguments, but it didn't address the problem of waiver at all. And so I think, that's an open question moving forward about, when the rules of waiver and forfeiture actually apply. And what about other arguments? I mean, the court in the CMS decision, for instance, addressed the statutory question and the arbitrary and capricious questions. It didn't address other bases that the district court ruled on, such as the 10th Amendment argument brought by the states or the non-delegation challenge. And it didn't specifically discuss pretext either, which is an interesting new doctrine in the last few years, as we all know. And so maybe it was couched in some of the summary language in the court's per curiam opinion, but it wasn't specifically addressed. So we're not really sure what to do with those types of arguments that the court just didn't reach. And finally, and I think most importantly from a public policy perspective, this decision takes the Solicitor General up on her invitation in their reply brief to basically transform HHS from a sort of check writing and fiduciary agency that administers these insurance programs into a federal public health agency. And that should be concerning because there's no real limiting principle on what the secretary could do as it relates to health and safety. If the statutes the court cited are broad enough to allow this type of regulation, it's hard to see what other types of decisions couldn't be made under that same heading. So those are some of my observations. I'm happy to turn this over, but that's a quick summary of the decisions. Obviously colored a little bit by my experience, but anyway, happy to turn it over now.
Thank you, David. Doreen?
So first of all, thank you, David, for setting this so thoroughly and so well. My feelings are probably kind of the opposite of yours, which is less happiness about the OSHA decision, although my feelings on that are very mixed because I keep going back and forth on whether the OSHA rule was a good idea on policy grounds and somewhat relief on the CMS. But that's not what I want to focus on. We have limited time and you can talk for a day on each of these topics. So I'll try to stick to my notes, and I have 6 points to make, but I want to start with something that David said towards the end and on which I'd like to hear the views of my co-panelists, which is, I think David is completely right that for both these cases, the Supreme Court kind of finished the case, even though this was only a question of emergency procedure. And I think David points that if this was dispositive, maybe there wasn't enough briefing is something we need to keep in mind. I do think these were dispositive, and I'd like to hear whether my co-panelists agree. I want to make one general statement about public health policy, and then 4 observations about OSHA and 2 about CMS. And I hope I can do that in 5 minutes. So generally speaking, when it comes to public health policies, a traditional view is public health response should start low and go up. So the first point of response should be on the local level, with states next and the federal government coming in. Though in practice, for big public health issues, we always have a multi-level response. Think from the Flint contamination, the Flint crisis, the horrible event that happened there, to hurricanes. We usually do have a multi-level response. The question is, what sphere should each of the levels take rather than who should act? That doesn't answer the question for these specific measures, but I want to remind you that we do usually see a multi-level response for every public health crisis. At the very least, the federal government has a bigger purse than individual states and can offer support. Talking more specifically about these measures, let me start with the OSHA decision. In terms of the statutory interpretation, I think the dissent had the better argument here. And the reasoning is that I think the dissent was right, that there's nothing in the statutes that draws the line that the court drew of hazards particular to the workplace versus general hazards. And we have historically seen OSHA measures that address things that come up in other contexts, such as sanitation and electricity. That doesn't mean there wasn't a very good argument for the Supreme Court to strike down the ETS on, but I would expect it to focus more on the criteria for granting an ETS. We know that ETS have been rarely used. We know that they have been struck down before, and the courts narrow the requirements. I was a little surprised that more of the debate and more of the decision wasn't focused on whether this is a grave danger across all workplace and whether this was necessary across workplace. As it was, I think the statutory interpretation here was unconvincing. And that's independent of the major question doctrine. The second thing I want to address directly is the major question doctrine. I have 3 issues with it, 2 general and 1 is applied here. The first thing is the major question doctrine as we currently use it is undefined. It's basically, I know it when I see it, and that's the way it was applied in the OSHA case. We have had such standards before. It's not unheard of in our legal system, but it's a tricky way to do law because it gives little guidance to parties across the board. If the goal of the major question decision, as I understand it, is to curb an administrative discretion and make sure that an administrative agency doesn't step into the area of litigating from its executive bench, there are other more principled ways to do that than a doctrine that's so well-defined. For example, New York City uses a non-delegation doctrine called Borelli, in which they really try to parse out, is the administrative agency litigating or acting as administrator with a multi-criteria test. That's one way. In general, we will strike down your actions retroactively because Congress did not authorize them and we think it's going too far, without giving guidance on what this means, seems to me a less principled way to do this. And I also see the doctrine to some degree as an escape route from overturning or narrowing the current non-delegation doctrine, which is a very weak non-delegation doctrine. I think if you want to say we need to have a stronger non-delegation doctrine, you should say that openly rather than use major questions as a way to not confront the current non-delegation doctrine. In this case in particular, I think applying major questions is tricky. And here's why. An ETS is an emergency power. And the weights in the OSHA Act is not uncabined. In fact, the OSHA Act carefully circumscribes when you can use an ETS, and the lower courts did address those factors in their in issuing the stay, whether this is a grave danger and whether this is necessary. The core of an emergency power is you don't know how it's going to be used. Congress can't be more specific about an emergency power simply because you don't know what the emergency is and you don't know what will be needed. The vaccine mandate is certainly much broader than much else, but COVID-19 is a much bigger crisis than we've faced in the workplace before. I think saying that the ETS power is a situation where Congress did not give specific enough delegation is problematic because for an emergency power, it's really hard to do otherwise. So it's a bit of a strange application of the major question doctrine, which I think follows from the fact that the doctrine is so well defined. 2 other points, one a litigation point. The court, in the majority of the court here, in addressing the balance of equity, basically said, on one hand, we have claims of economic damage, and on the other hand, we have death. We can't decide between that. But when it comes to a stay, the court has to decide this question. One of the criteria for issuing a stay is what's the balance of equities, and I think the court has decided it. And it would have been appropriate for the court, if it thinks the balance of equity is in favor of the economic harm rather than the COVID harm, to be open about that. Again, this is not a case where saying we would rather not decide works, because the court is deciding, the court is issuing a stay. And finally, as it is, I think the effect of the major question doctrine is to remove areas in which Congress delegated power to an agency to the courts. I think the dissent here was right that on the who decides question, the way major question operate now is giving the power to the courts. And as problematic as certainly Congress isn't perfect and agencies aren't perfect, there's a lot to fix on both. But I don't think the courts are a better place to make policy for a lot of reasons. On the CMS question, I actually have 3 points. One is, in the discussion, the fact that CMS is basically a funding power issue came up. There wasn't a lot of that in the decision, and I was a little surprised by that. Second, in terms of the statutory interpretation, I hear David that there really is, I think David is completely right that the statutory interpretation here is in tension with OSHA, with the statutory interpretation in the OSHA case. I think it's the OSHA case that was wrong, but I think he's right that the court acted one way in the first case and another way here. And I think because I think the OSHA case was wrong, I think the court was right here in saying this is a broad delegation. It's backed up by specific delegations, not across the board, but for several of these institutions that give the power to regulate health and safety. And it's backed up by past practice. I think that's right. I think the CMS rule was most vulnerable is on the procedural question. And I think Justice Alito was completely right that we only rarely countenance exceptions to the notice and comments requirements. On the other hand, the secretary did give an argument, and I think the majority was right that 2 months time to create a 73-page document, given the way our administrative agency moves, is within the rights. But I think the procedural issue is a very real one and deserved calling out and pushing on.
Thank you, Dorit. And I want to insert a housekeeping matter before we switch over to Ilya. And that's just, if you do have questions for the panelists, please use the question and answer function. I think we have them potentially coming in from multiple directions, but if you could submit them through question and answer, that would be great. And let's turn now to Ilya.
I'd like to thank the Federalist Society for organizing this in a very timely way, and for my two previous co-panelists for their very thoughtful discussions. I'm going to start off by talking a little bit about the two Supreme Court decisions that were issued yesterday. I've also been asked to talk about the broader issue of state governments and the private sector and their authority or lack thereof to impose vaccination mandates. So with respect to yesterday's decisions, I'm in an unaccustomed position of moderation. That is that I'm sort of in between my two co-panelists, and that one of them thinks that both vaccine mandates were illegal. The other one, I think, Dorit, you can correct me if I have this wrong, but I think you believe that both are legal. I actually agree with the court in both decisions. So I'm sort of the moderate here. The New York Times once said that I'm a centrist, which I think is not actually accurate for most issues, but it may be accurate for this set of decisions. And I'll very briefly try to describe why I think that both decisions are right and not in any significant conflict with each other. The big difference is that the ETS OSHA mandate is much broader than the other one, and it stretches the statute much more. Here, I agree with the court in focusing on the major questions doctrine. If there's anything that's a major question, it's imposing vaccination on 84 million people, a large part of the workforce and so forth. That seems like a very big policy decision. But I do also agree with Dorit and all the dissenting justices when they say that the attempt to distinguish between dangers that are unique or primarily in the workplace and dangers that also exist elsewhere, I think that's unconvincing. I think if the statute, the way it's written, I think it permits regulation of a danger that exists in the workplace if it's a grave danger, regardless of whether that same danger also exists somewhere else. However, the words grave danger are the ones that I think are crucial here, in that the ETS authority is limited. It's a special circumvention of normal procedures, so it can't be imposed for just any danger. It has to be a grave danger. And here is where I think the indiscriminate nature of the ETS rule dooms it in that it imposes it on almost all employees of employers with over 100 workers, regardless in most cases of the actual degree of risk that they face. And importantly, the agency only found a grave danger to exist for unvaccinated workers. And this means that the grave danger, if it exists at all, only exists for a group of employees who could very easily mitigate it themselves simply by getting vaccinated. And if OSHA under ETS has the authority to regulate or impose constraints on anything, even if it's a danger that can very easily be mitigated by the employees themselves, then almost all activities that we engage in ordinary life and in the workplace can potentially be considered grave dangers and restricted. Even walking down the stairs is a grave danger. If you don't look where you're going, you can fall and seriously injure yourself. There are many other examples like this in almost every workplace. So I think there's an important difference between a danger like this, which is very easily mitigated, and one which the kind of thing is more typically regulated by OSHA, where its mitigation is harder. It might be more costly. It might be something employers prefer to avoid, and so forth, or incentivize the employees to avoid. Here, that's simply not the case. And this, to my mind, is the real problem with the scope of the ETS rule, though ETS could perhaps be used to require vaccination in some narrower circumstances where, for whatever reason, there are employees who cannot mitigate, perhaps immunodeficient employees and so forth. And I think if the court had gone the other way on this, it would have given OSHA almost a blank check to use ETS to regulate virtually every aspect of the workplace. And I think that would have been very problematic. Those who might trust the Biden administration with this power think about, what if Donald Trump becomes president in the future, or some other Republican? Do you trust that person? And I think it's important, therefore, to have at least some major questions, constraints, even though I readily grant that, as Dorit says, it's a vague doctrine, its precise boundaries are fuzzy, but this is not a close borderline case for that doctrine. This is one where if the doctrine is going to be imposed at all, this falls within it. I also agree with much of what Justice Gorsuch said in his concurring opinion about non-delegation, but non-delegation, while I favor enforcing it more rigorously, it's not a doctrine that's as well developed by any means as the major questions doctrine. So I can readily understand the court in a decision that they had to write within just a few days, and totally understand their reluctance to go deeply into non-delegation and how it works and to really break new ground there, whereas I don't think much new ground had to be broken to deal with this through major questions. Briefly on the CMS case, I think here, you just have a differently worded statute. You have various provisions which say that CMS can regulate to protect, quote, the health and safety of patients and service recipients in facilities that receive Medicare and Medicaid funds. And I think, the exact boundaries of what counts as health and safety can be fuzzy. And in borderline cases, there might be challenges based on the spending clause, which might work, or based on other statutory interpretations principles, but I just don't think this particular case is close. If there's anything that relates to the health and safety of patients and service recipients, it's preventing or at least limiting the spread of a deadly disease that might kill them. And here, it's worth noting that the population we are dealing with, hospital patients, nursing home patients, and so forth, particularly in the Medicare case where they are elderly, they are people who are especially vulnerable to COVID-19. Dorit probably has the exact data on this, but as I understand it, something like 30 or 40% of all American deaths from COVID-19 were in nursing home and long-term care facilities. And this is a group that includes many people who are immunodeficient and can't easily avoid the problem through simply by getting vaccination themselves. But in any event, the wording about grave danger actually is not in this statute. So a health and safety risk, which is significant, but not quite a grave danger, that's something that CMS can still use to protect against. And again, this does not threaten to give the Secretary of Health and Human Services authority over all of society or even all of public health. It's limited to people who work in these facilities, though I know there can be some borderline questions about independent contractors and the like. I do recognize there's this provision about the selection of employees and the like, but I think the court's response was correct. This is not directly saying you must hire X person or you can't hire Y. This is simply saying whoever you do hire has to obey certain rules. And with any kind of regulation of any sort, even a purely administrative one, if you have employees who just refuse to obey the regulation or whatnot, then the employer might have to discipline them, or in the extreme case, even fired him. So I think this particular provision should be read in the context of the statute as a whole. And therefore, what it does is it should forbid direct federal control of hiring criteria, but not some indirect impact that comes from the fact that whenever there's a regulation of any kind, employers will often have to enforce it by saying employees who don't obey the regulation may get fired or penalized or what have you. Much more could be said about both cases, but that's at least my general perspective on the two and why the two are different and why I think the court got both cases right, though there certainly were some lacuna in their reasoning in both cases. And, I think the product that we saw reflects the fact that this was put together very quickly and therefore may be an example of the concerns that some people on both right and left have raised about sort of the court deciding cases on the emergency shadow docket, as it's called, and in some cases, very important cases. This is not the first. We've also had the eviction moratorium and some others. Briefly on the states and the private sector, I think by contrast with the federal government, which has only in some ways quite limited authority to impose vaccination mandates, state and local governments, at least as far as the federal constitution is concerned, have pretty broad authority to do so under their police and public health powers. The Supreme Court said as much in Jacobson versus Massachusetts in 1905. Some people interpret Jacobson as a complete blank check for all vaccination mandates at the state level, or even as a blank check for almost any public health measures. I don't read it quite that expansively. The court specifically said that maybe constitutionally exemptions would be required for people who face grave health risks from a vaccine. And there, I think it's also fair to say that if the evidence just shows that, a vaccine just doesn't work or the like, then that might also be unconstitutional. But in general, this authority is pretty broad. To my mind, it would be useful to draw a distinction between a paternalistic vaccine mandate, which protects solely or almost solely the person who gets the vaccine, versus one that's intended to limit the spread of disease to other people. That distinction is not in current Supreme Court precedent. I think perhaps it should be. Even if it's not going to be in the precedent, it's at least a relevant moral consideration for anyone who values liberty. But I should add that at least even currently, the COVID vaccines do in fact significantly constrain the spread, albeit less so with the Omicron variable than previous ones. And I think that's so I do not think COVID vaccine mandates are in fact the purely paternalistic kind. Finally, with respect to the private sector, a number of states, and I'm sorry to say mostly conservative Republican states, have enacted laws preventing even private sector employers or businesses from requiring vaccination of their employees or of customers. I think this is wrong from a health point of view. It's also wrong from the standpoint of liberty and freedom of association, that even if you don't think the government should impose certain vaccine mandates, it makes perfect sense to allow private firms to do so. Among other things, this respects the diversity of preferences that people have. Some people are more risk averse than others. It should be perfectly acceptable to businesses to cater to the more risk averse by having vaccination requirements, and also employees who are less likely to get severely ill. They might be better employees for obvious reasons. And that's also a decision that a private business should be allowed to take. There's some irony. There's been a lot of scrambling of traditional ideological alignments under COVID. One is on the left suddenly taking a very permissive attitude towards emergency measures that severely restrict civil liberties and the like, which they would not do in other contexts. On the right, they have forgotten much of their devotion to private property rights and freedom of contract and the like. And in few places is that more evident than in a debate over private vaccine requirements.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.